Hello, and thank you for joining today's Roads and Bridges webcast. Our topic this afternoon is how to avoid and respond to work zone lawsuits, sponsored by the American Traffic Safety Services Association, also known as ATSSA. I'm Ryan Curtis with Endeavor's Building and Construction Group, and before we dive into this great presentation we have in store for you all today, let me explain how you can participate in it. If you have any technical difficulties during today's session, simply type your issue into the Ask a Question box and a member of our team will assist you. You can also click on the question mark help button in the upper right-hand corner of the screen. We also welcome your questions during today's event. We will answer as many as possible during the Q&A session that will follow the main presentation, but please feel free to send in your questions at any time. Once again, to do so, simply type your questions into the Ask a Question box and click on the send button. And lastly, please be aware that today's session is being recorded and will be available on the Roads and Bridges website within the next week. You'll be notified by email when the archive is available. Now, it's time to meet today's speaker. Chip Darius serves as the president of the Safety Priority Consultants, LLC. He has over 30 years of experience as an occupational safety and health professional and frequently serves as an expert witness in legal cases involving work zone safety fatalities and catastrophic injuries. He has conducted international training on work zone safety for the International Road Federation, the IRF, and serves on the IRF Global Safer Work Zone Practices Task Force. Now, let me turn things over to our presenter. Chip, the floor is yours.
Thank you very much. Good afternoon, everyone, and welcome to our session today on how to avoid and respond to work zone lawsuits. I'm Chip Darius, and I'll be your guide for the next 20-25 minutes or so, and then we'll get to your questions. Obviously, this is a complex topic, and people have lots of detailed questions, usually in relation to specific events or specific circumstances. So let me say right off the bat, I'm not an attorney. Nothing in this presentation should be taken as legal advice, especially since we're not sure where you're calling in from, or it might trying to apply the legal advice. So our focus is on the United States and the system of law in the United States, and we're going to give you a lot of information today. So quick overview. We're going to look at a case study to start off, and then we'll look at some concepts in order, how to avoid court as best you can, some terminology you should know and understand, how the legal discovery process works, what happens in a civil lawsuit from beginning to end, so you can understand the process. If you do end up in court, what happens in court, what you should expect and what you should be prepared for, and then we'll talk some about the consequences of ending up in a work zone related lawsuit. Now, this is America. We have a lot of people. We have a lot of attorneys. And we have a lot of people in America that like to use attorneys. So litigation is sort of a constant issue facing people who work in the road or who provide services in the road. So let's get right to it. We're going to start off with a case study. This is from one of the fatality cases that I was retained on. It's long settled. And any photos I'm going to show you are okay to show because they're considered public record. There won't be any gore, so don't worry about that. Here's a photo approaching the scene of the incident. As you can see, we have a two-lane, two-way road separated by a double yellow, so it's a no passing zone. We have a roadway curvature to the right and proceeding up a hill. There's not much of a breakdown lane on the right-hand side. There is a guardrail, and if you look in the background, you can see the posted speed limit is 40 miles an hour. You can see a white utility truck up the hill ahead of you there. If we zoom in a little bit more, picture pixelates a little, but you can see posted speed limit 40. Utility truck parked partly in the breakdown lane and partly in the westbound lane on this particular road, with two readily visible cones and then a third cone sort of behind that. So there's only 3 cones in use at this location. As we get closer to the incident scene, we can see that there was a flagger doing a flagger's job. There's a handheld stop slow paddle. There's some clothing items in the road. None of the things that you see is the individual. He's already been transported by ambulance. But as we get closer, you can see this is the hat that the person was wearing. This is the Bluetooth that was in his ear at the moment of impact. Over on the side of the road, we see one of his shoes. And again, just to put that back in perspective, that stone wall is over on the left-hand side of the road. And if you look carefully, you can see the one shoe over near the side of the road. And there's a close-up photo of it. Our flagger was standing in the road trying to do his job when this car came through, being driven by a 95-year-old man with one eye and no depth perception. And because of the lack of advanced warning signs and the lack of clear and positive messaging to the motorist, the individual chose to drive between two of the three cones that were behind the truck, striking the flagger. Here is a photo of the front of the car where the flagger was struck. The indentation in the hood is from his hip, and the damage to the windshield is from his head. After he was hit, the flagger flew 65 feet through the air and then slid 85 feet on the pavement before coming to rest in the opposite traffic lane. The first oncoming vehicle was being driven by a nurse who stopped and rendered aid almost instantly, but the damage was done and our flagger passed away. What happens in a situation like this? The police get called, 911 gets called, ambulances come, news reporters come, OSHA gets involved. And at some point, somebody says, this wasn't right, and we need to get some fairness for the family. So an attorney brings a lawsuit on behalf of the individual. In this case, it went on for several years and resulted in a very sizable award for the family. However, the flagger is still dead. So we have the family side of this, we have the human side of this, we have the legal side of this, we have the OSHA side of this. It's actually quite complicated. You're here today to learn something about how to avoid being part of a situation like that. So question number one is, how are we going to avoid going to court? Well, we have a lot of lawyers. We have a lot of people that like to use lawyers. We have a society that's very quick to get a lawyer. So avoiding court entirely is a result of several elements: doing the right thing, keeping good records, being prepared, and being as proactive as possible. So the steps involved in avoiding court involve understanding, number one, 4 elements of a tort claim. A tort claim is a claim that's brought in the event of personal injury or when someone's claiming monetary damages. A tort claim has 4 primary elements. There has to be a duty, there has to be a breach of that duty, there must be an injury or harm of some kind, and there must be a logical connection between the duty, the breach, and the injury. That's called causation. So in our situation with our flagger, there's a duty on the driver to drive on the correct side of the road. There's a duty on the driver to obey signals from a flagger. There's a duty on the traffic control supervisor to set up a work zone properly in accordance with the MUTCD. There's all of these duties for different parties. The next question is, was there a breach? Yes, there was. There was no advance warning signs. There was an inadequate number of cones. There was inadequate number of flaggers. There was 1 flagger, not 2, on a state road with a posted speed limit of 40 miles an hour. These breaches of the standard can be shown. Do we have an injury? Yes, we have a worker who passed away. And can we draw a connecting causal line between all of those things? Yes, there was a duty, someone didn't do their job. Because they didn't do their job, there was an injury, and those are directly connected. So these 4 elements of a claim have to hold together, otherwise the lawsuit falls apart. If there's no duty, if there's no injury, if there's no breach, then it's very difficult for that lawsuit to survive. But the lawsuit can still be brought. The claim can still be made, and it still has to be defended. So the best thing your agency can do if you want to avoid ending up in court is to meet or exceed the standard of care. The standard of care is a legal term that applies to the watchfulness, attention, caution, and prudence that a reasonable person would exercise in those circumstances. In other words, what would a reasonable person do? Or what would a reasonable person not do? So if you fail to meet the standard of care, the legal term is negligence. You've fallen below the standard of care, you've done something wrong, or you failed to do what you ought to have done. That's called negligence. And the damage that results can be claimed in a lawsuit. In order to avoid court, you need to understand the different things that go into creating the standard of care in a particular set of circumstances. And these can go from very high level all the way down to very specific and situational. So at the high level, we have OSHA standards, Occupational Safety and Health Administration, and you may have a state OSHA in addition to that. So federal OSHA, Federal Manual on Uniform Traffic Control Devices, AASHTO, some of the national organizations, these organizations issue standards, and the standards need to be complied with. If they're not, there's a breach of the duty. At the state, county, and city level, you may have issues there as well. There can be protocols, there can be local ordinances. For example, you might have a specific requirement for cone heights or sign sizes on specific roads, like state roads compared to town roads. Those have to be met. Then there's the work to be done. The general contractor is responsible to ensure that everyone on that job site is working safely and to coordinate the work to avoid injury. So they have a duty under the multi-employer citation policy for OSHA. At the company level, there's policies and procedures and training and record keeping. There's inspection logs and ensuring that you've set up the work zone the way it's supposed to be set up. Those are all things that need to be done. And all of those things create evidence. And the evidence can be requested or demanded in the course of discovery in event of a lawsuit. Then there's a contract. The contract might have very specific requirements, things that you have to do or things that you're not allowed to do under the contract. Again, those bring duties into play. And you're using equipment that was made by a manufacturer, like a TMA, a truck-mounted attenuator. It has to be used on the right kind of vehicle in the right way with the right connections. Otherwise, you're not using it the way it was intended to be used. Then we look at the industry itself, what are typical practices, and then we have standards like ANSI and MASH. These are national consensus standards. So there's many ingredients that can go into the soup that creates the standard of care for a particular set of circumstances. So here's an example photograph. Take a look. Do you think the standard of care was met or not met? Well, the first question is, whose standard is it and who is supposed to be protected and how were they not protected? So one allegation that could be made here is that there is a failure to protect a visually impaired person from falling into this work zone. So that would be Americans with Disabilities Act. Also, the MUTCD requires that pedestrians be properly protected and routed around dangerous areas. We also have OSHA violations because there's unprotected rebar sticking up. That's an impalement hazard. And we got some folks on the other side with clipboards. So somebody's taking note of this and they should do something or should stop someone from doing something wrong. So clearly there's some breaches in this standard without being exhaustive in this photo. Here's another example. So we got three yellow things, sand barrels, and then we got another yellow thing, a forklift, and the forklift is not as forgiving as the sand barrels. So that's not a really good place to park the forklift. It's not going to absorb the crash properly. And if somebody hits that forklift, they will claim rightly that didn't belong there. Here's another example, broken equipment, a complacent flagger, somebody with no escape route. They weren't trying to do that in their flagger class. So deficiencies can be brought to bear when someone is concerned about a breach of duty. Terminology for you to be aware of is there's a plaintiff, that's the person who brings the lawsuit. There's a defendant, they're the one that is defending against the allegations being made. Plaintiff brings the lawsuit, defendant defends against the claim. In the United States, our system of justice is adversarial. What that means is the plaintiff gets a lawyer and the lawyer fights tooth and nail for their client. Then the defendant gets a lawyer and the defendant fights tooth and nail to defend their client. And the lawyers fight it out, literally. Demand things, refuse things, use legal privilege, make sure the law is being fully applied in favor of their client. And the point is, it is controversial. It is a fight. And hopefully the fight gets settled before you get to court. But it doesn't always work that way. The civil lawsuit process has multiple steps to it. Let me just walk you through this briefly so that you have an idea of what happens. So at the bottom of our arrow on the left-hand side, we have the complaint. The complaint gets filed, and that is where the plaintiff tells the defendant, here's what we think you did wrong, and here's what we want you to do about it. The defendant then answers the complaint, and that's a written response that says, we agree or disagree with each particular point of your complaint. Then the lawyers start exchanging demands for discovery. We want your training records. We want your worksite inspection records. We want to see your purchase orders. We want to see your warranties. We want to see the operator's manuals. Lots and lots of information may be brought into play. And interrogatories, where questions are asked and answers are given in writing. Then there's depositions. A deposition is just like being in court. It's sworn testimony under oath. You have to tell the truth. And that's where they ask people questions. It's a fishing expedition to understand all the nuances and all the things that happened or that people claim happened. Depositions are a very important part of discovery. Typically, there will also be a site inspection of some kind. Expert witnesses are retained and they come and inspect and measure and take photographs and video and scans to figure out exactly what happened. And then those experts write reports. You might be asking, why do we need an expert? The issue is that the attorney cannot testify about the facts of the case. They have to engage someone who's a subject matter expert to provide testimony about the facts of the case. And that's what an expert witness does. Then those experts write their reports and then they get deposed and they get asked questions about what their opinions are and how they arrived at those opinions, what standards apply. And then the lawyers take all of this evidence and they put their heads together and they try to see if they can settle the case before it goes to trial. So it might be a mediation or an arbitration, but 95 out of 100-ish cases do settle before they get to court. When lawyers are good and people clearly have a grasp of the facts, the majority of cases will settle for monetary amount before it gets to court. If it can't settle, then it goes to trial. If it goes to trial, it's either a state court or a federal court, and the rules are very different. Federal court is for the big dogs and the big money and interstate conflicts, where a state court would be fine for something local. After the trial, there's a judgment. Somebody's found guilty or not guilty. The penalty is assessed, and one side or the other side might appeal somehow based on the process. So it's a long and complicated process. It costs money. It takes time. It's a pain. It's not something you want to be a part of. So in order to avoid being a part of it, you got to understand some legal terms and see how those fit into the process. So one of the terms is negligence. Already mentioned that. Negligence is failing to behave with the level of care a reasonable person would have exercised under the same circumstances. Did you do what a reasonable person would do? Did you not do what a reasonable person would not do? If you failed in that mission, then you can be charged, or it can be alleged that you were negligent. Some other terms you might run into are subpoena. A subpoena is a demand, an order issued by the court requiring you to appear somewhere or ordering you to provide documents or evidence, or both. Subpoenas are very important. Do not disregard them if you receive a subpoena. You have to comply with that, and if you need advice on how to do that, that's what lawyers are for. Another very important term is called spoliation. Spoliation is where you have evidence about a case, but you put it through the shredder, or you have video of the case and you delete it, or you have training records that don't exist, and then suddenly they do exist because somebody just makes them up on the spot. You're not allowed to destroy or alter or fabricate evidence in relation to a lawsuit, and there's big penalties if you do, so avoid that. In our system of justice in the US, we generally look at civil cases and criminal cases. Civil is where there's money involved, and criminal is where someone's going to jail. And then all of this information is brought before the trier of fact. The trier of fact is a judge in a bench trial or a jury in a jury trial. And a jury could be 6 or 12 or some other number of people, depending on where you are. But the trier of fact is the one that makes the decision. So in order for the trier of fact to arrive at a decision, they have to be presented with evidence, and that's what the discovery is for. Discovery is to gather all the information related to the case. Written information, photographic information, videos, electronic files, payroll, tax returns, lots and lots of information gets pulled together, and it all has to be sorted to make sure that it makes sense. Work zone inspection records. If you're not keeping inspection records, that's not good. If you're keeping inspection records and they show that you're consistently doing the wrong thing, well, there's a failure of training somewhere or a failure of supervision somewhere. It's better to have records, and the records should be driving you to a quality process. Training records, contracts, diagrams, sketches, witness statements. Obviously, when the police or OSHA are involved, they want to talk to the people involved and take statements. But even things down to emails, texts, and social media postings about the case can all be brought into evidence. So if you're involved, be very careful about what you write or what you post or what you share around the water cooler. This is important information, and it needs to be controlled and collected in a proper fashion. You may be a witness. There are two kinds of witnesses when it comes to a lawsuit. A fact witness can only use their 5 senses to give information to the trier of fact. They can tell what they saw, what they smelled, what they tasted, what they heard, what they touched. That's it. They can't say something like, I think he was reckless, or I think he was speeding. They can say, I saw that person drive that car through our work zone. They can tell what they saw, but they can't apply judgment. An expert witness, on the basis of their training, helps the jury or the judge to understand the evidence, and they can testify beyond their five senses. For example, I've been involved in well over 350 lawsuits. Not all of them work zone related, but many of them work zone related. And in that situation, they want to know my background, my training, my credentials, my experience, what kind of work I've done. Why am I qualified to help the jury understand? And it's my job to prove to them that I have information that will help them to understand. Because ordinary people don't spend their time in work zones, and they don't understand OSHA or the MUTCD or anything like that. So the role of the expert is to be impartial. The expert has no financial stake in the outcome. They get paid by the hour, period. They don't make more money if you win or less money if you lose. Their job is to tell the truth. Straight shooter, not a hired gun. They apply their skills and their experience for the best outcome of the facts of the case. So the facts are what drive the bus. That's why it's really important to keep good records. Site inspections typically do happen, and that expert does get deposed under oath in order to help move the process along. Now, as we talked about, if the whole process does not resolve, if it cannot be brought to a close, then at some point there's going to be an appearance in court. Courtrooms look something like this. There's a lot of variations, but there's a big high bench in the back. That's where the judge sits. There's a lower bench down in the front. That's where the clerk and the people who support the judge happen to sit. And on the left and right-hand side, there are witness boxes. And then over on the right side in this photo, that's where the jury would sit. And every seat might be occupied, or it might be fewer than the number of seats, depending on the case involved. And then there's a separation. And closest to us in the photo, this is the public gallery. So that's where people sit while they're waiting to be called to testify. You notice the swinging gate at the bottom toward the right side of the photo. If you're ever involved in court, do not go past that gate until you are called. That's like no man's land up there. That's where the attorney and the attorneys for both sides, the jury, the judge, the official people are up there. You stay behind that gate. So what happens in court? Everything's failed. Settlement is not going to happen. The process is jury gets selected. There's opening statements from both sides. The plaintiff presents their side first. There's a direct examination where they ask you very straightforward questions, and then a cross-examination where the other side tries to poke holes in your argument or your memory or what it is you have to say. Then the defense puts on their case, and they do a direct, and they also do a cross. And then after that, there's closing arguments, and then the jury deliberates or the judge deliberates and comes up with a determination, a decision. So if you do ever get called to court, you're going to get a notice of some kind. You're going to be asked to appear in court, and that's official. You do have to pay attention to that. You should know the rules and expectations. Dress like a professional. Don't come in your greasy clothes or Bermuda shorts and a t-shirt. You want to look professional. Anytime you're even close to court, be very nice to everyone. The last thing you want to do is get called to the stand and realize that one of those jurors is one of the ones that you cut off at a red light close to the court. So be nice, be professional, get there early. Leave your phone and your electronic devices in the car. You're not allowed to have those in the courtroom. Obviously, no weapons of any kind in the courtroom. And be very careful about who you talk to. Don't make small talk in the hallway. Don't be talking on your phone about the case where people can overhear you. It's important to be very discreet. When you arrive at the courthouse or the courtroom, there's going to be metal detectors. Everything gets searched. You don't bring computers into the courtroom unless you have special permission. You'll find out which room you go directly there. Don't bring a pizza. Don't bring your lunch. Don't bring breakfast. It's a professional environment. And don't talk to anyone. Again, that's worth saying twice. Don't pass that swinging gate unless you're called. And one of the basic rules you should know is, just like you've seen on TV, you stand up when the judge and jury come in, and you stand up when they go back out as well. When you get called to take the stand, if you're called as a witness, be ready so that you're moving timely when you're called upon. You'll get sworn in, and you do have to tell the truth. So tell the truth. But when you're asked a question, just answer the question that you're asked and stop talking. It's not a time to tell a story. They're in charge. They ask the question, you answer the question, you're done. On the direct exam, it should be very much questions you're expecting. And on the cross exam, there may be some surprise element to it as well. And that's part of the excitement of going to court. If you've given statements in the past and you say something different this time, that's called impeachment. That's where they say, well, you said this before, you're saying this now. Doesn't make sense to us. Generally, courtroom is not as exciting as a NASCAR race. There's very few crashes and very few things catch on fire. It's very highly scripted, not like you see on TV. There's objections and rulings and overruled and sustained and that kind of stuff. And sometimes the lawyers have a big fuss and they go up in front of the judge and they have to have a sidebar conversation to work out some difficulty. If so, just sit there, mind your own business, wait patiently. At some point, you're going to be done with your testimony and you'll be told you may step down. When you step down from the witness box, you need to clarify with the attorney, am I done? I can leave the building, or am I subject to recall? Is there a possibility I might be brought back to the stand? You don't want to leave the building and then find out that they were looking for you. As we wrap it up, that would be the end of the court period, but it's not the end of the consequences. So think about our poor guy who got killed in the example that we opened with. His family is still without him. His church members are still without him. His dog is still without him. There's nobody to drive his car. The family or the relationships, the team, the company, contracts, OSHA, recordable rates, lots of things get affected by this and can have really long-lasting effects. Obviously, when somebody's dead, they're gone for the rest of the lives of the people that cared about them. Your company reputation may suffer as well. So it's really important to do the right thing. And that's the main point of today. Remember the 4 elements of tort. If you have a duty, fulfill the duty. If you have a duty, don't breach that duty. Do what you're supposed to do. Don't do what you're not supposed to do. Avoid causing injury. And if there is going to be an injury on the job, do everything in your power to not be the cause of that injury. Perhaps you have a worker in the road and somebody drives over your cones because they're drunk and high and otherwise a menace to society. But it's not your fault, or the jury should find that it's not your fault. If your work zone is set up properly, people are properly trained, you did everything you could to make that job site safe. At this point, we're looking for your comments or questions or anything that you would like to share with the group. So we'll send it back to Ryan.
Awesome. Well, that was an awesome presentation. Thank you so much. Now, a few of you have already submitted questions, so we're going to jump right in. And just a reminder that if you would like to send us a question, just type your question into the Ask Question box and hit the send button. So let's get into the questions. Question 1 is, should we keep work zone inspection logs on paper or electronically?
Well, these days people are certainly doing it both ways. And if you put it on paper first and then scan it in, it becomes an electronic record. So it might have 2 different forms of existence. But the most important thing is to keep some kind of record. Some places use a paper and pencil checklist. Some use an app on your phone or a tablet to kind of do red, yellow, green, okay, maybe not so okay, definitely needs help. Other places will use a dash cam and drive through their work zone and record the conditions there. The most important thing is to keep accurate records and to do everything you can to keep that work zone properly in condition.
Perfect. Next question is, how long should we keep our work zone documentation?
Oh, really good question. We see this a lot. So actually, records retention requirements can vary by state, and they can also vary by contract. As you may know, just from having lived in this country, there's a general rule of 7 years for like financial records, for your tax returns and things like that. Some states have a 10-year records retention rule. And for example, if you're doing contracts with the state or the federal government, they may have even longer or different retention requirements. So check with the attorney that advises your organization, check your company policies. And it used to be a big deal because you had to send a box of paper off to Iron Mountain or off to some long-term storage. These days, lots of things get scanned in, they turn into PDFs, and it doesn't take up much space to store those records for a really long time. So keep it as long as necessary, and then destroy those records when your attorney agrees that it's time to do so.
Perfect. Next question is, directly from a training team perspective, what if the training class/material covers the standards, however, an employee or crew does not follow them?
So what the attorney or the expert would say there is the employer knew what the standards were supposed to be. The employer obtained training materials that complied with those standards and provided those training materials to the employees. So the employer did their part, and the employees have been told what their part is to do. If at that point the employees are departing from the necessary performance, the question is why? Is it failure to supervise? Is it a one-off event? Was there some change at the job site that required something different? There's more information that we need. But at the end of the day, somebody gives instructions, somebody follows instructions, and it's really important to follow the standards. So if the standard requires 350-foot spacing on your signs, you better be close to 350 feet. It can't be 5 feet. Like in our opening example there, those cones behind that truck were 6 feet apart. Nowhere near enough advance warning.
Next question is, if a general contractor has site rules that are stricter than OSHA or MUTCD, do we have to follow the GC's rules?
Great question. The answer is yes. You do have to follow the rules of the agency that is in charge of the area where you're doing the work. So if they have set specific requirements for high visibility clothing or sign size or cone height or anything like that, yes, you do have to comply with those requirements, but it's by contract. If the GC's rules are more strict than the OSHA standards and OSHA were to show up, OSHA can only cite you based on their standards. OSHA cannot cite you for a violation of the general contractor's rules, but the GC can penalize a subcontractor for not following the GC's rules. You could be penalized monetarily or dismissed from the job or get a black mark. So short answer is you do have to go with the GC, but that doesn't necessarily mean OSHA would cite you for the same thing.
Okay. Now, can we put a bar across 2 cones to close a sidewalk, or do we need ADA compliant sidewalk closure barricades?
Great question. We see this a lot out in the field. These are very popular lightweight plastic devices, 2 cones, and you throw the bar across the top of it. As far as you're concerned, the sidewalk is closed. But if somebody's coming down that sidewalk and they're visually impaired and they're using a cane, they may not detect that crossbar until they trip over it or fall and get injured. The MUTCD does require ADA compliant sidewalk closures. It has to be cane detectable. So this can even be a city ordinance, a county or a state requirement, but at the very least, it's a federal requirement under MUTCD that sidewalk closures must be cane detectable. Therefore, they do have to be ADA compliant, and a bar across 2 cones doesn't do it.
Okay. And looks like the last question. If there is an accident in one of our work zones, should we keep the accident file for longer than 2 years, since there's typically a 2-year time limit to file a lawsuit?
It can vary. For example, if that person is so seriously injured that they don't have the opportunity to get legal counsel in time, there may be a change in the statute of limitations. Also, it's not guaranteed across all 50 states or across all jurisdictions that it would be just 2 years. So anytime you have questions about how long to keep evidence or which evidence to keep, consult with an attorney that can give you proper advice for your jurisdiction.
Perfect. And I'm afraid we've run out of time. But for those questions we didn't have time to answer, we'll be getting back to you via email. And that concludes today's webcast. On behalf of Roads and Bridges, I'd like to thank Chip for his awesome presentation, ATSSA for sponsoring today's event, and of course, all of you for joining. Have a great rest of the day.